Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to This Week in FCPA, Episode 113 for the week ending July 27th, 2018, the Trade Deadline Edition. First, a word about our sponsors, Affiliated Monitors. Founded in 2004, Affiliated Monitors provides professional independent integrity monitoring and ethics and compliance assessments nationally and internationally and across almost all industries. With its knowledge of effective ethics and compliance programs and cultures, Affiliated Monitors is respected for its work as the corporate monitor on matters ranging from multinational corporations to small and mid-sized companies and even individuals. Having served in over 600 monitorships, no one has more experience as an independent monitor than the team at Affiliated Monitors. For more information on how an independent monitor can help improve your company's ethics and compliance programs, visit our sponsor, Affiliated Monitors, at www.affiliatedmonitors.com. Jay and I have a full range of discussion items for you today. We talk about AI, data analytics, compliance, and the Houston Astros. We consider Mike Volkov's review on corporate culture, values, and the ostrich. The CCO looks at corporate activism in Compliance Week. We take a look at the DAAG Matthew Minor speech on M&A liability under the FCPA. We consider the business relationship and what your company's is with its suppliers on the Tesla example. What are some of the ways you can respond to information requests under GDPR? We take a look at Ben DiPietro's article on the downsides to using your founder, CEO, board chairman as a spokesman. We take a look at a blog post on assessing your compliance training programs and ask, will KPMG survive? We note the only podcaster in compliance who accepts queries via carrier pigeon, Eric Moorhead, on Compliance Beat. We take a look at my 5-part podcast series on the intersection of Shakespeare and compliance, and we conclude with speculation about who the Astros and Boston Red Sox might need to round out their team on the trading deadline of July 31. Thank you for listening to This Week in FCPA. This Week in FCPA is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, along with Mr. Monitors himself, Jay Rosen, and we would like to welcome you to This Week in FCPA, Episode 113 for the week ending July 27th, 2018, the Trade Deadline Edition. With the MLB July 31 trade deadline almost upon us, the Yankees, Indians, and Dodgers have all significantly upgraded their programs. Will the Red Sox and Astros do so? We consider this and then take a look at some of the week's top compliance and ethics stories. So, Jay, welcome.
Thanks, Tom. Lots happening. We've got 11 articles to touch upon, so we should jump right in. And you did a 3-part series this week about artificial intelligence, AI, and there was also a couple transactions that we highlighted in the space. So why don't you let our listeners know where your interest is in AI and compliance?
So, Jay, I got interested based upon an article I read in the Harvard Business Review, which really looked at how businesses would use AI, but they split it into 3 different angles, and that's what I did in my three-part spread this week. One was, what does AI bring to compliance? 2 is, what does compliance bring to AI? And then 3, when you put it all together, what do you have? This past week I was at a podcaster conference in Philadelphia called Podcast Movement. And while I was there in the evening, I was reading a book by Ben Reiter of Sports Illustrated about, did you know the Astros won the World Series last year, Jay? Have I mentioned that before?
I wasn't aware of that. I thought last we were talking was about the Houston Rockets, but congratulations to the Astros.
Yeah, how about that? Well, anyway, the Astros are the 2017 and reigning World Series champions in Major League Baseball. And Ben Reiter was Sports Illustrated, as I mentioned, reporter who wrote in 2005 2014 an article predicting that in 2017 the Astros would win the World Series, and the Sports Illustrated put George Springer on the cover, who happened to be the World Series MVP. So serendipity abounded. At any rate, I was reading his book Astro Ball while I was up in Philadelphia, and what struck me was the Astros followed this 3-part path as well. So I ended up writing a blog, kind of a book review, blog post summary, which really wrapped up these 3 parts. And the thing that intrigued me about the Astros' use of data analytics and AI was the following, Jay. They first used it in the area of talent acquisition to try to figure out who was the best person for them to take in the amateur draft and who to bring in as either a free agent or to trade for. Part 2 was use of data, and this is where I think they really outshone the rest of the league, although I think the rest of the league is catching up. They used data to help players improve. So the best example, I guess there are 2 best examples. Dallas Keuchel, sort of a mid-level pitcher, won now the name of the award for the most valuable pitcher award, top pitcher award, escapes me, but he won that.
Cy Young.
I'm sorry, thank you. Cy Young in 2015, and he had never been anywhere close to that. But then there is a guy named Charlie Morton, and Charlie Morton had a lifetime win-loss of, I think, 40 and 71, and the Astros signed him to a $14 million 2-year contract. The first year he went 14 and 7. The second year, this year of his contract, he's 11 and 2. His ERA has dropped from over 5 to under 3. And it's simply along the lines of the Astros took a look at not his release point, not his spin rate, not anything that is incredibly advanced, but simply that he struck out more batters when he threw a curveball, as opposed to a low to mid-90s fastball or an even lower slider. And so they got him to increase the number of curveballs he threw. And he is just, it's like finding a number 1 draft pick out of a guy who'd had a 40 and 71 lifetime record. So they are really using data to figure out who to pick, whether it be the draft or trade or free agency. And then they're using data to help the players improve. And now they're trying to use the data to make in-game adjustments. Obviously, the shifts they use are the biggest part of those. But I thought it was a fascinating and very serendipitous book for me to read while I was writing about artificial intelligence. And did I mention the Astros won the World Series last year? I guess I still have trouble believing it. Is why I say it so often, or maybe because I may never say it again. Nevertheless,
there were some people, Tom, that have said that your earlier critiques of the Astros led to them winning the first World Series. So it may have had more to do with the use of data analytics, but I think your constant haranguing also helped.
You know, I can't reveal the name of the source, but a very highly placed source did confess that to me.
So one other thing I wanted to note, also included in our show notes about AI, we refer to an article from Scott Shaffer at Kreller. And Scott talks about a little bit of different bent, that although there is AI that is used in doing due diligence, sometimes it also has to be combined with the human touch. And he talks about a young analyst who was very excited that besides going through the normal PEP list and things like that, that this analyst had listened through to a video, and a few minutes in, he came up with another piece of information that was critical. So in terms of AI, there's still always going to be needed that human touch, especially under due diligence. So we link to that article in the FCPA blog. And next up, we have something from our good friend Mike Volkov in his compliance and crime and what's the third C? Compliance, crime?
No, crime, corruption, and compliance.
There you go. So Mike decided this week to take a look at something we looked at last week, which was the Beam Suntory settlement for $8 million to settle both to settle an FCPA violation. And really, it's just it's instructive on what not to do. And this looks back at a period back in India where Beam thought that they were paying bribes sometime between 2006 and 2012. And they had their audit company do a report in an investigation, and they thought that there was something wrong. And then they had their Indian investigators do a report, and they thought there was something wrong, but still they took no action. Then they went to their U.S. attorneys to take a look, and still they took no action. And finally, they ended up the government found out about them. They still did not take any action. They did not receive any credit for being cooperative, but luckily they finally settled the matter. So basically, what Mike kind of details in real painstaking detail is that over the course of nearly 2 years, it was revealed that there was an unwillingness to investigate uncover misconduct. No wonder why that Beam eventually settled for $8 million. And at the end of this, Mike says that really Beam failed the true test of its corporate character by not taking action while others weren't looking at them.
Yeah, it really, and when you read the SEC cease and desist order, it's just striking. And Mike did a great job of bringing all that out. But Beam clearly knew something was wrong and basically did do exactly that, put their head in the sand, become an ostrich, and or engage in conscious avoidance. So Jay, Katie Smith, who's the CCO, or I suppose CECO more appropriately, over at Conversant, penned a great piece, I thought, on corporate activism in Compliance Week. And Katie really took a look at corporate activism from the CCO perspective. And what she said, she really, I thought, drew it out to say that when you have an active corporation, socially conscious, moving in the right directions, it's really an offshoot of the compliance function and the company's culture. She pointed to the example of Microsoft and its employee base, Google and its employee base, both who objected to their employers' contracts with ICE. And she started with, look, you had a company where hundreds of thousands of employees felt safe enough to raise their hand and raise their voice, literally in unison, saying, we don't want to be a part of ripping families apart at the border. Please stop this, even as a business. So I thought it was a really interesting angle, and that she really pointed to how a culture of compliance can really lead a company in many different ways.
So I'm back on, Tom. Sorry about that. Can you hear me okay?
Yep, sound great.
Great. So next thing we have are a couple articles, one by Matt Kelly in Radical Compliance and one by Dick Casson on the FCPA blog. And they're both recapping remarks that we also linked to that were made by Matt Miner, who's a deputy assistant attorney general. And basically what the issue now is how FCPA enforcement should be linked to inherited liability. And basically carrying on with the new FCPA policy that was actually adopted into the federal sentencing guidelines, the same benefits and certainty that they're offering for going to, self-report to the government, they're also basically extending this program to work within the M&A context. And basically, to avoid successor liability, if a company hits 3 marks of the corporate enforcement policy, and if they voluntarily report violations, if they cooperate in the investigation, and they take corrective action, it will be presumed eligible for declination of a prosecution. So this is a long, something that the DOJ and the SEC have been trying to promote for most of the last 5 to 7 years, to come up with some type of certainty that the business owner can use to make plans and to decide whether or not it makes sense to do the calculus and to self-report. Another thing that was brought up in the DAG's comments were that there is an FCPA opinion process where if you want to potentially consider a merger, that you can go to the DOJ and get some feedback. So he also stressed in his remarks that this is something that can be utilized, and it's another tool that people should avail themselves to. So the bottom line is that these are one of the first series of remarks by Minor, and it still continues the trend of the Trump administration and the DOJ to want to make it acceptable and to want to help the business community in terms of how they deal with self-reporting. Anything I missed on those, Tom?
No, Jay, I guess I would just kind of opine that this seems to me to be certainly a continuation and continuity of prior DOJ policy. We have seen several declinations in this area. There were declinations in this area prior to the release of the 2012 FCPA guidance because they were cited in that guidance. And certainly there have been multiple declinations in this area since that time. I think the DOJ has always given a favorable view and review to companies that engaged in pre-acquisition due diligence, use that for the basis of remediation after closing, including training of high-risk employees, incorporation of the acquired company into the purchasing company, and then forensic auditing of books and records, and if anything nefarious turned up, turn that over, information over to the government. So this seems to me to be just a continuation of that prior policy. Perhaps it's more certain now, but I would have always advised a company that if you have engaged in these steps, you're pretty closely going to be in a safe harbor at any rate. It does continue the department's efforts to encourage self-reporting. But in the M&A context, I always leave people with the following, Jay. If someone was engaging in bribery and corruption before you bought them, and they are engaging in bribery and corruption after you've acquired them, it's no longer they who are engaging in bribery and corruption. It is you who are engaging in bribery and corruption. So there is a very good business reason not to engage in bribery and corruption. And these remarks to me, I don't want to say simply they're common sense, but they are a continuation, I think, of what the DOJ has been telling us at least since 2012.
Great. So what has the man from FCPA been thinking about in this week's Compliance Week?
So for those of you who may not know, I am the man from FCPA. I write a column for Compliance Week, or blogs for Compliance Week, in addition to my monthly column for Compliance Week. So I write 5 blogs a week there. In addition to the 5 blogs a week, I write on my site, blogs I write for SCCE, the FCPA blog, and numerous other sites. So you might say I'm a blogging fool. Nevertheless, this week I wrote about a couple of things I wanted to highlight on our podcast, Jay, because this one really intrigued me about Tesla. Now, this is not about Elon Musk's, tin hat wearing breakdowns from aliens who are stealing IP. This is not about robots who may or may not be functioning. This is about him, or rather Tesla, going to its key suppliers and not asking for a cost reduction, not asking for a rebate on future purchases, but asking for suppliers to rebate monies that have been paid as far back as 2 years ago. And that's almost unheard of. Squeezing suppliers is certainly a well-honored tradition in both manufacturing and the energy space. Been on both sides of that. But I just can't remember ever seeing a company trying to squeeze money out of its suppliers for goods and services that were delivered and paid for. That speaks to several different things. Obviously, the cash problems at Tesla, first and foremost. But from the FCPA perspective, and the reason the man from FCPA wrote about this is, what does this put the business relationship of the supplier in now? Typically, you would have a company and a vendor, standard business relationship. The vendor supplies goods or services, gets paid. Company receives goods or services and makes payment out. Well, what happens if you loan money or rebate money back after you've been paid, not discount as a vendor, but you get money back? And Tesla said they wanted partnerships with these companies they wanted these companies to invest in the future of Tesla and themselves. That sounds to me suspiciously like a partnership. And if you're going to move into a partnership, not only are you going to have different business relations, but you're going to have different legal relations. So I just found this fascinating from the FCPA angle. So I thought that was a good reason for the man from FCPA to write about it.
Great. Next up, we have another article about responding to individual requests from under the GDPR. And what are your recommendations on that?
Well, Jay, I can't say they're my recommendations because we took a look at an article from the NYU Compliance and Enforcement blog by Jeremy Feigelson, Jane Shevitz, and Christopher Garrett, where they pose some interesting questions. So if you get a request for information, certainly we've seen multiple of those. Do you have to respond? Can you ask for additional information on the request? How quickly do you have to respond? Do you need a form, policy, or procedure for individual responses? Can you refuse to comply going forward? So I would recommend really everybody taking a look at this blog post because I thought it raised some very real world questions and answers that U.S. companies particularly need to consider going forward.
Great. Next up, we have an article from Ben DiPietro, the Wall Street Journal. This is about corporate reputation, and the article is entitled Recent Controversy Spotlight Risks of Having Your CEO as a Spokesman. And in the piece, Ben takes a look at Mark Zuckerberg at Facebook, Elon Musk, who we were just speaking about at Tesla, and your favorite pizza selling fool who just got his name taken off the University of Louisville Stadium, Mr. John Schnatter with Papa John's. And all three are recently, unfortunately, in the spotlight because of comments they made that garnered criticism and thrust their companies into the spotlight, again, drawing attention to the question of risks an organization faces when the person who runs or owns a controlling interest is also the chief spokesman. And in this article, they talk about some key questions again to ask. Is this the first time the CEO or leader has said something or done something that caused a controversy? Was an apology issued? Was it timely? Was it sincere? What is the reaction of key stakeholders such as customers, employees, and investors? And then what is the performance track record of the CEO? So these are things that I know you and Amy Barnard-Vaughn spoke about yesterday in a podcast that you taped a week ago that was specifically focused on Papa John's. And there is just a lot out there that you need to be responsible for on a reputational basis. And as Ben points out, things are really exacerbated if the CEO is so closely tied to the company. Tom,
so,
anything?
Yeah, I was reminded of the words of the person who vetted Sarah Palin for Senator McCain before she became his VP nominee. Yeah, high risk, high reward. and it can be very high reward if your CEO is associated with a brand. And I think Schnatter rode that puppy as far as he could. The high risk is if the CEO, founder, chairman of the board goes down flaming or using the N word in during sensitivity training and is outed, it's going to be very difficult for the company to make a comeback. And if you contrast that with just a horrible situation Subway found itself in with Jared Easley, is that his name?
I want to say Fogelson. Doesn't that sound right? Or Fogelman, maybe?
Maybe. Their spokesman, who turned out had been a child abuser, it certainly hurt, but it wasn't catastrophic to Subway like Papa John's. And Papa John's is now in this huge, very ugly public spat with Mr. Schnatter. So high risk, high reward.
Jared Fogle. Don't want to leave the wrong name hanging out there. So we have some stuff about compliance training from our friends at Kaplan and Walker. What do they have to say?
So first of all, if you haven't bookmarked the following blog, you should. It's the Compliance Program Assessment blog. And Jeff Kaplan and Rebecca Walker are two of the top legal/compliance practitioners around. Jeff is Mr. Conflicts of Interest. Rebecca, investigations, harassment, Me Too, as well as compliance programs. But they're both just excellent. And the blog is excellent. And I was drawn to a recent blog post entitled Assessing Compliance Training, where they really laid out some specific questions that you should consider to help assess your compliance program. So we've linked to it. They've got plans for really every level, looking at its risk base. What's the role of the board? What about the role of senior management, the participation of employees? What type of media do you use in the content? Is it of quality training? Is it memorable training? Is it long? Is it short? What's the feedback? Does it integrate into your compliance program? Then do you train your third parties? So lots I thought that really helped the compliance practitioner and would help a compliance practitioner going forward.
Great. So we've got an article now coming from the Financial Times. And if you remember back to the financial crisis of about a decade ago, it was talked about that there were certain banks that were too big to fail. And right now, this article takes a look at KPMG, which is one of the big four global accounting firms. And they're talking about, with the spate of recent missteps and different legal trouble that KPMG has fallen into, that they're wondering whether or not KPMG is too big to fail. If they were to go under and that would leave only the big three, there would not be the amount of competition that there is now. And they also talked about one of the potential solutions in this situation would be to break off the consulting arm of KPMG and let KPMG Audit continue as a standalone company. And at that point, they would have to spend more of their resources and time dealing with these potential issues so they could really work with their reputation. So again, it's really critical about how your company responds to crises. And it seems that over the last several years, KPMG has had more than their share. Any thoughts on your end, Tom?
Yeah, there was one other thing I wanted to highlight, Jay, and that is the following, that the Bank of England started looking at KPMG. And the significance of this is that the Bank of England and its regulators do not regulate KPMG. They regulate insurance companies and financial institutions. The reason they're looking at KPMG is because they're concerned about the long-term viability of the firm and, frankly, the missteps that it has engaged in recently. And they are, considering telling the companies they regulate, their client base, you shouldn't use KPMG. And when you have someone who is really that far down the line saying to its regulated industries, you really shouldn't use this auditor for whatever the reason, and whether it's continued viability, whether it's screw ups, mess ups, whether it's non-professionalism, really doesn't matter. It shows the serious nature of the reputational scandal that KPMG is under. I think I assume KPMG will come out of this in some form, but they may be in very different format and shape going forward. So when you've got the Bank of England telling its banks, these guys may not be around. You may want to look at somebody else. That's pretty serious.
Definitely. So to add to your busy podcast schedule this week, in addition to you doing stuff on AI, you also took some works from the Bard and figured out compliance lessons that we can learn from Henry IV, Part 2, Henry V and St. Crispin's Day, Much Ado About Nothing, Othello, and you had another podcast that hit today. So what's your favorite points that you'd like to touch on from the Bard?
So on Henry IV, Part 2, of course, it's the line, the first thing we do is kill all the lawyers. So I talk about the legal profession, the compliance profession, and really how they're different now. In Henry V, you're absolutely correct. I talk about St. Crispin's Day speech, but where I really draw inspiration from, Jay, is before he made the speech, Henry V went out incognito and listened to what his men were saying so that he could answer their queries and their questions and their fears and their concerns. And I use that as an exploration or an opening of an exploration of creating a social media program for compliance, allowing a two-way form of communication. On Wednesday, I took a look at Much Ado About Nothing and using social media. And Benedict and Beatrix were at each other's throat literally during the entire play, with some of the greatest witticisms in all of Shakespeare, but everybody but them knew they were made for each other. So really, their friends were a presager of social media. Yesterday, I took a look at Othello and the Clash of Cultures, and Othello was perhaps for me the biggest clash of cultures in all of Shakespeare. A Moor who worked in the service of the Venetian Republic, and the trouble he got into through Iago, murder of his wife, and his suicide. And today I looked at King Lear, who has my favorite character in all of Shakespeare, the Fool. And I use it directly to tell people, if you're going to create bribery and corruption schemes, do not put them in PowerPoint presentations. As funny as that may seem, we've got companies who have done that. But the Fool also it presages as well, talking truth to power. So I thought he was a great character to end this week's series in. I'm going to develop some further topics for this podcast series. It's been hugely successful and hugely popular. And I had a lot of fun doing it. So what more could you ask for in a podcast series, Jay?
Maybe talking a little bit about the trade deadline in baseball. Can we? That would be the only thing more I'd want to talk about today.
So on the Astros front, they got a catcher. We lost our frontline catcher, Brian McCann, to a knee surgery. He says he'll be back in September, but. We brought up a guy from the minors, Max Stassi, who's one of those players that really never stayed in the big leagues too long, but he has flourished under the Astros system. We're going to have to see if he flourishes at the major league level. And I can't remember the name of the catcher we traded for, but we traded for last year's Golden Glove winner, who's in the final year before he gets free agency. So we filled that slot. The question in my mind for the Astros is a closer. Our number one closer, number one himself with some horrendous outings, and he's now on AAA trying to get his way back. Last year, the Astros solved the closer problem by just having the starters close. And over a 2-week period on the playoffs, that seemed to work pretty well. And maybe that's what they're planning on doing again. But we have to make it that far. So I think everyone in Houston is waiting to see if we're going to get a closer. What about the 70 and 25 Red Sox, I think, running at a 680 pace winning percentage? What are their needs, if any, Jay?
They really needed a number 5 starter. They've had a couple folks who were we had our knuckleballer who was suspended earlier in the year, Stephen Wright, who's just coming back. And we also had somebody kind of be on the IR for most of the year. So we've gone out and gotten a right-handed starter named Nathan Eovaldi, who played in the division for Tampa Bay. So I think that kind of firms up the number 5 starter position. We are solid with our closer. And, the thing might be is we might need to bring in another bat. But as you point out, the Sox, I think a couple days ago, were 40 games over 500, which is incredible. And as we've spoken about before, it's going to be tough. Whoever does not win that AL East, and you have the situation in the Central too. If the Astros don't win it clean, and Seattle wins or something like that, you're going to have potentially these teams that are playing over 680 ball who are going to go into the one-game playoffs. So it's very interesting how things line up this year. I guess I was also just noticing that it looks like Mike Judge sprained his wrist and might be out. Actually, fractured his wrist and might be out for
Aaron Judge.
Yeah. Oh, Aaron Judge. I'm sorry, not the guy from the King of the Hill, right?
No. So this, that could obviously be a serious blow to the Yankees, and if you have a fracture, that's a minimum 6 weeks. Yeah. So that could be a pretty serious loss for them. But you're absolutely right on the, on a one-game playoff, anything can happen, literally. Literally anything, because in 2015, the Astros beat the Yankees in a one-game playoff and made it to the next level. So
of course, you don't have to remind me of 1978 and Bucky Effin Dent.
Bucky Effin Dent, yeah. I vaguely remember Mr. Effin. Yeah. Yep. Well said.
So any traveling for you? You just got back from the podcast convention. Anything else on the books?
So I think that's going to be it for the next month. I'm going to enjoy the heat in Houston.
Great. Well, I am out in the Boston area, so this is a treat for me doing a podcast almost in the afternoon as opposed to early morning on the West Coast. And I'm out here with my daughters, and we are going to go see the Sox play the Phillies Monday night, weather permitting. So looking forward to getting my annual trip in at Fenway. And that pretty much does it. So I think once again, we've proven that there is lots of things happening in the FCPA world. AI is very important, and we'd like to thank all of you for spending some time with us on the FCPA in the week of. So on behalf of Tom Fox, the compliance evangelist, and myself, Mr. Monitors, we'd like to thank you for joining us. Have a great weekend and keep enjoying your summer. Thanks a lot.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of This Week in FCPA. If you have any questions for Jay, you can reach him at jrosen@affiliatedmonitors.com. I'm available at tfox@tfoxlaw.com. I hope you'll join us again next week when Jay and I explore some of the week's top FCPA compliance and ethics stories. This Week in FCPA is a part of the Compliance Podcast Network.